Hello, everyone. We are live on Cinco de Mayo with Level Up Law. Welcome and thank you for joining us today on Level Up Law. South Carolina looks forward each week to leveling up your legal knowledge on the different areas of law that we handle here. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services. I'll be the host of the webinar today, along with our producer, Kenneth Elliott from our IT department here at SCLS. Today we are joined by Attorney Lanier Sims and Regional Benefits Paralegal Mary Lou Seymour from our office in Greenwood, South Carolina. This is a part two of their two-part series on considerations for special needs children. In part one, Mary Lou and Lanier discussed considerations when your special needs child is under 18, and today they'll be talking about considerations when they are 18 and over. Remember, as you view today's presentation, this is not legal advice, but just general information for the public. So you should always consult with your own attorney for any special legal issues that you have. At the end of today's presentation, we will provide information on how to apply for free legal assistance at South Carolina Legal Services and how to access all of our public information and resources. Kenneth will post a recording of the presentation on our YouTube channel along with the slides that Mary Lou and Lanier will be using today. Just go to YouTube at SC Legal Services. Now, even though you'll be in listen-only mode, be sure to take advantage of this opportunity and put in questions that you have in the question box. The chat box you can use if you have any technical difficulties, and Kenneth will be keeping an eye on that. As time allows, Mary Lou and Lanier will provide some general information to answer any questions that you have. So again, thanks so much for joining us today. And Mary Lou, I'll let the presentation be turned over to you. Take it away.
Okay, and thank you, Susan. This is about, we're going to go over the Social Security Disabled Child and SSI income, what happens when you turn 18, special education for students over 18, healthcare decisions, power of attorney, and guardianship or conservatorship, voting and selective service, the draft, making a will, and housing and employment. We're going to start with what happens when your disabled child turns 18, your disabled child that is drawing Social Security or SSI benefits. The first thing that happens is when your child turns 18, Social Security is going to start sending the benefits directly to the now adult child, not to the parent who has been the representative payee. If you don't think your child can handle his own benefits, you can request that a representative payee, yourself or someone else, be appointed. You need to take a letter from your child's doctor to Social Security stating that he cannot manage his own benefits before he turns 18. Don't wait till he turns 18, and request to be appointed the rep payee. Even if you are your legal guardian for your now adult child, you still have to inform Social Security that you want to be the rep payee. They're not going to know that you're the legal guardian unless you tell them so. Now, income and assets. Now, this is for a disabled child under 18 that's getting SSI. The parent's income and assets are deemed available to that child, not for disabled children that are drawing off of a parent, but for an SSI child. When the disabled child turns 18, they're no longer deemed available, and this may result in an increase in the child's benefit. But when the child turns 18, the child is now responsible for paying their own food and shelter out of their benefit. If they don't pay their pro rata share of living expenses, their check is going to be reduced by 1/3. And Social Security is not going to know if they are paying their pro rata share. And pro rata just means however many people are in the household. Like if there's 4, you have to pay a fourth. but you have to tell Social Security. Social Security calls this in-kind support and maintenance. You need to inform Social Security that your child is now paying his share of living expenses. And as with everything else, Social Security has a form to report your living arrangements and in-kind support on, and that's Form 8006. The next thing that will happen is at age 18, they're going to redetermine their disability under adult rules. Adult rules are different than child's rules. This could happen exactly at age 18, which is unlikely, or it can take a year or two. I've had 20-year-olds that are still drawing as a child that now they're being redetermined as an adult. You will receive a notice that the redetermination is underway. They'll tell you to send in medical records, etc. And then if Social Security determines your child is still disabled as an adult, they will let you know. Or if they determine they're not disabled as an adult, they'll notify you of that. If they notify you the child is not disabled as an adult, you can request an appeal, and you have 60 days to appeal. If you want the benefits, including Medicaid, to continue while the appeal is underway, you must appeal within 10 days. And remember, once your child turns 18, he or she must sign the appeal request unless you are the legal guardian, in which case you would sign and attach your guardianship papers. Now, Social Security SSI disability as an adult. To establish disability as an adult, you must show you're unable to engage in substantial gainful activity that is suitable to your age, education, and past work history on a full-time basis because of your physical or mental limitations. What is substantial gainful activity? If you earn more than a certain amount per month gross, you're considered to be engaging in SGA. For non-blind individuals, 2021 SGA amount is $1,310, and that's gross, not net. Blind is $2,190. This changes every year. So if you're not engaging in SGA, you then must establish that your condition meet or functionally equal the medical requirements in the listing of impairments, or failing that, show that you're unable to engage in SGA because of your physical or mental limitations. What this kind of boils down to is adults under 50 years of age must establish they can't engage in SGA even at the sedentary, unskilled, low-stress level of work. And sedentary means sit-down work where you don't have to walk around, you don't have to lift or carry anything that weighs more than 10 pounds. Unskilled is something that you can pick up without a minimum of 30 days training. And low stress can even be working by yourself in a room all by yourself. Now, you can request an attorney or disability advocate to assist you with your appeal, and Legal Services does handle this type of appeal and may be able to help you. There's also another factor you want to consider. This is continuing benefits under Section 301. That is a section in the Social Security Act that allows your payments to continue for people who no longer are disabled, but they are engaged in a program under voc rehab. The benefits can continue even though the child isn't disabled as an adult until the voc rehab program ends. The child must already have been enrolled in the voc rehab program prior to age 18 redetermination. It's too late if they've already said you're not disabled at age 18. It's too late to run out and get in voc rehab. Enrollment in voc rehab is often included in a child's IEP transition. You check with your school to see if this has been done, and if not, check with voc rehab to see if you can get your child enrolled for them. And make sure Social Security knows that your child is enrolled in voc rehab. So in summary, as your disabled child approaches 18, you should check and see if your child is enrolled in a voc rehab program through school. Decide if your child can manage his benefits on his own. If not, take a letter from the doctor to Social Security and request to be appointed rep payee. If you get the notice from Social Security saying your child is not disabled as an adult, request appeal, and if you want continued benefits, do that within 10 days. If your disabled child will still be living with you or others, inform Social Security that they will be paying their pro rata share of living expenses, food and shelter. And of course, contact an attorney or disability advocate for help with your appeal if you so desire. And Legal Services does handle this type of appeal. Thank you, and I'm turning it over to Lanier now.
Thank you, Mary Lou. Okay. Well, good afternoon, everyone. As Susie mentioned at the beginning, my name is Lanier Sims. I'm an attorney in the Greenwood office of South Carolina Legal Services. I'm going to be talking to you about a few more things to consider as your disabled child approaches 18. So first, just talk about what happens at that age 18. We talk about the age of majority or the age that someone becomes an adult in the United States, and specifically just in South Carolina, someone becomes a legal adult once they turn 18, and that is not dependent on whether or not that person has a disability. So essentially at age 18, unless something has been done otherwise, that person's considered capable of making their own decisions, and that otherwise would be if, for instance, a probate court had declared them incapacitated, and we'll discuss what that means in a few moments. But first, I want to talk about the special education impacts for students as they reach the age of 18 or reach when they might be leaving school and furthering their either education or work. So first, in South Carolina, a student has the right to attend school so long as the school year starts so long as their 21st birthday occurs after the school year starts. So even if a student is in their senior year or even their junior year, so long as they are 20 before the school year starts and don't turn 21 until after, then they're allowed to stay in school for the remainder of that year. So education for students with disabilities, what we talk about, special education, is required to be provided to any student who can still attend school. So since in South Carolina, someone can still attend school up until they're 21, that means that they're required to receive their special education services until the end of that 21st birthday school year. But one of the things that happens before we reach the age 21 mark is that the rights for the student, or rights transfer to the student under IDEA, which means that the student becomes essentially the signer of the IEP. The parents can still participate in the IEP process, and generally most students will sign a waiver allowing their parents to continue to receive records and receive notices. But once that student is a legal adult, they are the one who has the rights under IDEA. So a student who's 18 may sign what we call a power of attorney that gives the parent or someone else, like a grandparent or other adult, the authority to exercise the student's education rights if they just don't want to have that responsibility and they're capable of signing that power of attorney. Or the student could have a court-appointed guardian, which might handle who's allowed to make educational decisions. But IDEA also provides this exception kind of to the guardianship or power of attorney rule, where if a healthcare provider determines the student isn't able to make their education choices on their own, then someone else can be designated to make education choices. So while for some things we'll talk about today, a parent would need that power of attorney or guardianship under IDEA for a student's rights to be given to a parent or other family member, all that's required is that determination from a healthcare provider. And generally each school district has their own guidelines of what's sufficient to satisfy that requirement. And even before the child reaches 18, but this is something we didn't talk about last time, for under 18 children, the schools are required to begin transition services, which would include both the goals for the student and the services that would be required or that would be provided to the student in order to meet those goals. So starting at age 13 in South Carolina, these transition services conversation starts during the IEP meetings. This is a little bit younger than the actual IDEA requirement, which is 16. But in South Carolina, around 8th grade generally is why they do it at age 13. The IEP team will start discussing the student's goals for post-graduation or post-high school. The main goals will be whether or not the student is obtaining a regular high school diploma or some type of alternative diploma, such as an employment diploma or some type of trade certification, and what the student hopes to do after high school, such as continuing their education in college, going to vocational training, obtaining employment, or just having the ability to live independently. It could really be anything. Those are just the main ones, the main groups of what it might look like. And then the services would be designed to achieve the goals. So that might be what classes the student's going to take if they're on track for a regular diploma or an alternative one, what occupational therapy or vocational training the student might need to meet their goals going after high school. Students are required to be invited. They're not necessarily required to attend IEP meetings where transition services are discussed. But when you think about it, you want the students' input on what they want to do with the rest of their lives and kind of get them on track to be able to obtain that. And then also the school has to identify and let the parents and the student know of any other agency that might be coming to that type of IEP meeting, such as the Department of Voc Rehab, or it could, for instance, be a special needs program director at a university or college that the student might be interested in. But everybody just needs to be aware of who's going to be at those meetings. And finally, as students leave high school, those who are graduating with a regular diploma or are just aging out of special education are required to be provided with what's called a summary of performance. Essentially, this is a separate document from the IEP that includes what that student's goals were and interests were, what areas they excelled at or had different needs in during high school and school, what type of accommodations they were receiving, and what type of accommodations they might need in a future school or employment setting, depending on that child's goals and wishes. These summaries of performance aren't required for students who leave with a GED or alternate diploma and whose eligibility for services has not terminated. So for instance, if a child was 18 or 19 and they could still be eligible for services until 21, but they take the GED or leave with some type of alternate diploma, they're not necessarily required to be provided this, but nothing actually prevents the school from providing one. And generally, it would be best for the child to have something to give to a future college accommodations department or a future employer. So now we're going to talk a little bit about healthcare decisions and how those are made for special needs children. So again, on a general basis, once a child turns 16, they're allowed to consent to their own healthcare decisions other than operations. And as an adult, a person is responsible for making all their own healthcare decisions unless that person has been declared incapacitated by a probate court and a guardian's been appointed, or two physicians, sometimes like one in emergency situations, have determined the person's unable to consent. And then if that person's unable to consent, then the decisions would be made by a health or court-appointed guardian, a medical or healthcare power of attorney, or any family members that would be eligible to make decisions for that person under the Adult Healthcare Consent Act. So the main takeaway here is unless one of those other things has been satisfied, the adult child at 18 is still going to be the adult at age 18 is still going to be making those decisions unless one of those other things has occurred. And now kind of on that line, talking about the power of attorney versus guardianship and conservatorship, a lot of times we have people come to us wondering whether they need a power of attorney if they're special needs child, or at that point special needs adult can sign a power of attorney, or whether they need to pursue a guardianship and a conservatorship. Now there are advantages to if you can do a power of attorney, because that's simply a document that's signed by that person. And then a guardianship is obviously a court case, which is a more expensive process, but sometimes it's just necessary to do a guardianship if that person can't do a power of attorney. So first off, what is a power of attorney? It's a legal document that grants someone else the right to legally act for the person that executes the power of attorney. So if, for instance, I wanted someone in my family to be able to make decisions for me in the event of my incapacity, or just to make decisions for me coinciding with me being able to make those decisions on my own, I could execute this document and it would give them that legal authority. The power of attorney can be limited to just some areas, such as if I just want someone to pay my bills, I can give them a power of attorney to handle my finances, but they can't make any other decisions for me, like selling my like where I would live, or what I might do with other things in my life. Or it can be an all-encompassing, it can give them the right to buy and sell property for you, to make healthcare decisions for you, to really just do anything you legally could do on your own. But when we talk about the power of attorney, the person who's granting it has to have legal capacity, and that essentially means that they understand the nature of what they're doing, they understand the legal ramifications of signing this document and giving someone else that authority, and essentially have the knowledge available to be able to enter into what's a legally binding document. And a durable power of attorney is one that continues even after someone becomes incapacitated. So if I am able to execute a power of attorney today, but for some reason I become incapacitated or go into a coma or something and can't make decisions on my own, a durable power of attorney would allow the person that I named to continue to make those decisions even once I become incapacitated, and that's why these are a good alternative to a guardianship or conservatorship. So a guardianship and conservatorship are two different things, but very similar. They're both handled in probate courts. They both are going to require a determination that the person is incapacitated before a guardianship or conservatorship is granted. The difference is mainly in what they handle. The guardianship relates to personal affairs, like healthcare decisions, living arrangements, educational decisions, even voting. Or the conservatorship is business financial affairs, investing, buying and selling property, spending money, basically anything handling money, whereas the guardianship is more personal life decisions, not financial ones. When a court's deciding, once a court's determined a person is incapacitated, then the court decides whether a guardianship, conservatorship, or both are granted. And this is going to very heavily depend on what that specific person needs. If the person is only receiving an SSI check and has no other assets, then it's unlikely they're going to even need a conservatorship. But if that person then, for instance, gets a life insurance benefit from a family member that passed and they suddenly have a lot of assets, then that person may need a conservatorship so that the conservator has the authority to invest that money and to use it in the best interest of the disabled person. So if someone doesn't have those assets and only a guardianship is appointed, then the guardian would still have what we call basic authority to handle the person's financial affairs. Since they don't have a ton in assets, they can still pay bills. Generally, as the representative payee, they can do that anyways. But it just, they can still handle the person's financial affairs to the extent necessary to enable them to act as that person's guardian. So when we talk about incapacity, this is one of those subjects that could be talked about for the entire length of a presentation, but generally it means the inability to effectively receive, evaluate, and respond to information or make or communicate decisions such that even with appropriate available support, they cannot meet the essential requirements for their own health, safety, or well-being, or manage their property or financial affairs, to their, or for the support of themselves or their legal dependents. And so those two kind of requirements are where we get the guardianship or conservatorship actions. This inability has to be a true inability. So someone could be capable of making these decisions, but simply choose not to, or have a little bit poor judgment, but it doesn't mean that they're unable to actually make responsible decisions. So the ultimate determination of what means someone is incapacitated is truly up to the judge, but this is why the cases require evaluations by medical professionals and other individuals to determine whether or not that person is truly incapable of making those decisions or whether they just have made bad decisions. So now just to kind of touch on two other things that become relevant once someone turns 18 in the government areas, the voting and selective service. So every citizen of the United States and South Carolina who's 18 and up, who properly registers, is allowed to vote. No one is automatically disabled from voting just because they have a disability, but the probate court in a guardianship action can remove someone's right to vote. So a person under a guardianship can vote unless the paper specifically says that the right to vote is removed. And in the guardianship forms, there's a list of rights that might be taken away, and voting is one of the ones in that list. So unless that box is checked, anyone who has a disability can still vote. But when we talk about the actual voting process, that might be a little bit different for someone with a disability. So voters who have a disability can actually receive assistance within the voting booth, whereas everyday individuals aren't necessarily allowed to have anyone else in there with them except maybe small children. And there are other means of voting available to make voting more accessible to those individuals with disabilities, such as curbside voting, absentee ballots, and early voting, not having to deal with the same crowds. are good options for voters with a disability who might struggle to actually vote on election day. So Mary Lou reminded me at the beginning of this, obviously the draft no longer exists, but selective service system does still exist, and federal law requires all men 18 to 26 to register for the draft. This may not be something that a parent or guardian of someone with a disability thinks of, because we think, even if the draft were re-implemented, they wouldn't necessarily be drafted, but there's no specific exemption from at least the registration portion for any physical, mental, or cognitive conditions. So there may be an exception if someone is hospitalized, institutionalized, homebound, or would not comprehend the nature of registration. And there is a process in place to send that evidence to Selective Service, and they will review it to determine if registration is required. But registering is really as simple as returning a Selective Service card if you receive it in the mail, getting a Selective Service card at any local post office and mailing it in appropriately. High schools often have places where students can sign up as they reach age of 18. And now in the 21st century, we have an online registration system. So someone can ask for an exception just for registration, or they can just go ahead and register. And that's important because that failure to register is still a crime and could be prosecuted. Now that's less likely, but what is more likely is that it would result in permanently barring that student from receiving any federal financial assistance, federal job training programs, and if they ever wish to obtain federal employment, like at the post office, as we just remembered, or any other government agency. So before we get into the guardianship conservatorship, or sorry, after getting into the guardianship conservatorship stuff, we're going back to probate court and talking about making a will for someone over 18. Now, making a will is available for anyone once they turn 18, even if they have a disability, but there is a requirement that that person be of sound mind. So South Carolina law allows anyone who's of sound mind and who isn't a minor to make a will, and even if a person's disability makes them physically unable to sign the will, then they can still direct someone else to sign their name in their place. And the witnesses to the will have to be able to say that the person was of sound mind. Now that determination is ultimately up to the probate court judge of that specific case if the will is challenged when it's being probated, but we do have some guidance on what sound mind means. So having sound mind with regards to the will context really just means someone understands the property they have an interest in. They know who their heirs, kids, spouses, family members who might receive that property are, and finally know who they want to leave the property to. Now that is what's required for kind of the mental state to sign the will. And then obviously, as I noted at the bottom there, they have to know that they're signing a will. You can't say, Grandma, can you come sign this, whatever, and then it be a will and her not know that it was a will when she signed it. That would make it invalid. So if someone isn't of sound mind, for instance, Bob comes in and he knows, he has a house and some land and a boat and some cars and some guns, and he wants to leave that property to his new live-in girlfriend, and he tells you, I don't have any kids, I don't have any other spouses to give this to, and then come to find out he has like 3 or 4 kids. Now that could be a matter of him not telling the attorney, or it could be a matter of he doesn't really know how many kids he has, and that would kind of make the will invalid. Or if an older person comes to make a will, and they know, they can name all of their kids, grandkids, and know which one of them they want to leave that property to, but they start telling you, I only have, a half interest in this, or I don't have any property really to leave, and then come to find out they have, a trust fund somewhere with a house available as well to distribute, that could cause problems with them being able to execute the will. So if someone is not of sound mind, then that will isn't valid. If they had a previous will that was executed with sound mind, that one could still be valid if the invalid one's validity was, or if the invalid one's revocation of the previous one was based on the newest one being valid. So there's a possibility that someone could try to make a new will only to be told that that one isn't valid, and in doing so they revoke the previous one, and now they don't have any valid wills. If someone does not have a valid last will and testament when they pass, then they're considered intestate, and that person's property then passes according to state intestacy law, which goes to the next closest heirs, such as someone's spouse and kids, parents if they have no spouse and kids, and on down the line. So once people transition from the school area and start going out into the world, they're going to start running into more housing and employment issues on their own, or they may be running into these even as children while living with their parents. So with regards to housing, we have several different federal laws, such as the Fair Housing Act, the American Disabilities Act, which require housing providers to make accommodations and modifications for individuals with disabilities. And also the Fair Housing Act prohibits discrimination in the sale, rental, and financing of dwellings on the basis of membership in a protected class, one of which is having a disability. So specifically under the Fair Housing Act, someone can't be refused renting or buying a home or anything like that based on their disability. And under the other laws that we'll discuss, someone who is living somewhere can request a modification to serve the needs of their disability. When we talk about discrimination, it can be proven two ways. Either first, they are kind of on their face treating someone differently based on their membership in a protected class. Some examples there: if you refuse to rent, or you only rent to single men but not to single women, you're discriminating on gender. If you refuse renting to someone because they told you they are bipolar or schizophrenic or anything like that, and you use that as the reason to not rent to them, that's disparate treatment. You're treating them differently just because they have that disability. The other one might be a policy or practice that isn't outright discrimination as we normally think of it, but has an unfair impact on a protected class. And that might be some examples there. Evicting tenants who are victims of domestic violence, and because the vast majority of victims of domestic violence are female, while they don't say we're evicting female victims of domestic violence, that is what happens more often than not. And so that would be a disparate impact type situation. Now, some small exceptions: this does not apply to landlord rented buildings where there's less than 5 apartments and the owner occupies one of them, to single family homes that are rented or sold without a broker, religious organizations, or private clubs and senior housing. So once you get past the discrimination aspect and are actually living somewhere, then there may be something that you need changed or modified to help the person with a disability be able to fully use and enjoy the dwelling. The two options are a reasonable accommodation, which is just a change in a rule, policy, something that's necessary to allow that person with the disability to continue to live there, or a reasonable modification is an actual structural change to the dwelling in order to allow them to continue to fully enjoy the premises, such as a handicap ramp, widening a door, installing grab bars. when regards to a reasonable accommodation, the actual change is necessary if it frees them from something that impacts their ability to fully enjoy the property, enhances their quality of life, or enables them to satisfy the essential requirements of tenancy the same way a non-disabled person can. So for example, someone may constantly be late on rent because their SSI check doesn't come until later in the month. And so the landlord might have to make an exception or change the policy for that tenant to allow them to pay their rent on time because their late payments are due to their disability. Any change that's requested is reasonable unless it's an undue financial or administrative burden, or it's a fundamental alteration in the nature of the business or program. So for example, if the cost to the landlord is much greater than any benefit it would provide to the tenant, then the landlord could say it's an undue financial burden. Some expense is going to be expected when we're talking about accommodations or modifications, so they have to prove that it's an undue burden. Some examples of like a fundamental alteration might be a tenant requesting a landlord provide them transport to a hospital or something like that, when that's not something the landlord would normally offer. Again, whether or not they're reasonable, the requests have to be determined on a case-by-case basis. I already discussed some of the examples there, but I provided a few more just to give you an idea of what it would look like. But really and truly, the list of what a reasonable accommodation is could be endless. Now, when we talk about reasonable modifications, these are those structural changes, whether it be a handicap room, or I even included a little graphic there. It might be like soundproofing for someone who has a disability where, you know, loud noises like impacts them more than others. Under the Fair Housing Act, this reasonable modification is only, under the Fair Housing Act, they're only being discriminated against by refusing the reasonable modification if they refuse to permit, at the expense of the person with a disability, those modifications that would afford that person full enjoyment of the premises. So you'll note there that under the Fair Housing Act, the person with a disability might actually have to pay for the modifications. Now, under 504 of the Rehabilitation Act, a housing provider, which would mean someone who receives federal financial assistance, is actually required to make and pay for the modification as an accommodation, unless, again, we have that undue financial or administrative burden or a fundamental alteration of the program. So under those housing authorities, such as like a HUD-funded public housing agency or nonprofit, all of them would be required to actually pay for a modification if it's a reasonable accommodation and meets or it doesn't amount to an undue financial or administrative burden. But that would exclude the ultimate beneficiary of federal assistance. So if you have a landlord who receives Section 8 vouchers from a public housing agency, that landlord, as the final person that gets the federal financial assistance, wouldn't necessarily have to pay for these modifications. But that landlord receiving the Section 8 voucher would then have to at least offer it at the expense of the person with a disability to satisfy the Fair Housing Act. And when we talk about this, you know, people's first question is, what do I have to provide to the landlord? They do need some verification of the disability, but you only have to disclose the amount of information necessary to show the disability exists. This does not have to be medical records, although those can be used, and the disability may be known to the landlord already. Other things that could be provided would be like SSDI or SSI proof, just any information from that person that can verify your disability, like a doctor or a therapist. but you're not required to provide something signed by the doctor. And finally, and when we get into employment, the Americans with Disability Act is the primary law that covers accommodations and discrimination in employment, and specifically Title I. It prohibits the private employers, state and local governments, any employment agencies, labor unions, basically anyone from discriminating against qualified individuals with disabilities in any of their job procedures, hiring, firing, training, basically in any manner relating to that person's employment. The only exception being that this doesn't apply to private employers with less than 15 employees. So when we think of small local businesses, they'll likely be exempt, but any type of company, generally, if they have more than 15 employees, this is going to apply to them. So the first thing it does is prohibits employers from discriminating against qualified individuals with disabilities. That qualified individual means that that person can do or perform the essential functions of the job in question with or without reasonable accommodation. So it does not necessarily mean that someone, with no computer background, no computer science, applies for an IT job, happens to have a disability, and doesn't get the job. If they weren't qualified for the job, it's unlikely the employer is going to get in trouble for discrimination. But if that person is qualified, or maybe the most qualified candidate, and does not get the job, then there becomes a question of whether or not that employment was declined due to the disability. So the reasonable accommodations required under the ADA come in three main aspects of employment, which essentially mean, the first, ensuring equal opportunity in the application process. That would be the interviewing, hiring, firing process. The next would be the actual functions of the job and allowing, giving that disabled person what they need to be able to perform the essential functions of the job. And finally, making it possible for them to enjoy equal benefits and privileges of employment. So what does that necessarily mean? We talk about having the access to the job or being able to enjoy the job, making sure all areas of the job that other employees have access to or are accessible to the person with a disability by modifying the layout or installing a ramp or installing a handicap restroom if needed, anything along those lines. Providing different software, such as to individuals who are blind or deaf who may need screen reader software, or on the other side, like video phones for colleagues who are deaf. Accessible communications, that would again be both throughout the job, but in the hiring firing process, like the interview or any meetings. And then just changing policies, such as no dogs at work suddenly becomes, okay, those individuals who have a service animal for their disability are then allowed to bring them. And that covers all of the information I wanted to get out to you guys today. We are available for about the next 10 minutes if there are any questions, and I'll kind of turn it back over to Susie.
Hey, thanks, Lanier and Mary Lou, too. That was so comprehensive. I do not see any questions in the question box, but while I close it out, I encourage anyone to put one in there if they haven't. But let me thank Attorney Lanier Sims and Regional Benefits Paralegal Mary Lou Seymour out there in our Greenwood office for another great presentation about special needs children. And thanks to all of you who joined us today. We really do appreciate your interest in the show, this subject matter today, and other subject matters that we address along the way. Just remember that Level Up Law is a series of free webcasts every Tuesday at noon. Unfortunately, yesterday we had to postpone until today, thanks to the storm throwing out the I guess, electricity and technology out there in Greenwood, but we appreciate Lanier and Mary Lou letting us reschedule them for today. But anyway, every Tuesday at noon, we're educating the public on some of the common legal issues that we see here at Legal Services. And remember, all of those previous ones will be found at our YouTube channel. And if you found today's presentation helpful, which I am quite sure you did, be sure to go over to our YouTube channel and give this presentation a thumbs up. I've certainly given it a thumbs up right now, and also share the broadcast with others that you know that may be interested in this same subject matter. And of course, if you go ahead and subscribe to our YouTube channel while you're there and sign up for the alerts, you'll get a notification every time we post a new episode. And also leave a comment if you choose, and you can even let us know if there's another subject that you'd like to hear about on Level Up Law. And now, don't forget, you can see here on the screen all of our contact information at Legal Services. If you need legal help and you can't afford a lawyer, you might be eligible for free legal representation at Legal Services. So there's the phone number to call. Intake specialists are standing by Monday through Thursday, 9 to 6. But also, you can apply online, and we even have a Level Up Law episode about applying online, giving you some of the tips and tricks to make that online application a good one. Also, check out our website and follow us on social media to find out what's coming up next. It's always on our Facebook page, Instagram, Twitter, and all those wonderful sources. And we ask that you tune in next week when we'll be talking about how to challenge the South Carolina Department of Revenue before they take your tax refund for a debt that you owe to the government or a quasi-governmental agency. So that should be very informative as well. Well, I'm looking in the question box, and again, I think Mary Lou and Lanier, y'all were so comprehensive, both in parts 1 and part 2, about special needs children and considerations that we have for them both before 18 and once they reach age 18. So this was a terrific series, and thank y'all so much. And we look forward to everyone tuning in to Level Up Law next week. We look forward to having you back, and that concludes today's webinar. Thanks for tuning in.
Thanks, Susie.
Thank you, Susie.